right? You need to go right there. She's going to fingerprint you, please. Thank you. What are we doing on this? Is she pleading to both?
No, sir.
Which one?
Well, 41050 is being dismissed and she's pleading to 41051.
Same thing.
22-41051 is called Misty Carroll. That's you. You have to speak out so she can hear.
Yes.
Thank you. You are here with Mr. Dusler, your attorney, and the state's attorney is here. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in a summary?
Yes, sir, we can.
In summary, ma'am, this indictment alleges that on about May 27th, 2022 in Jefferson County, Texas, you committed the third-degree felony of credit or debit card fraud. Do you understand what you're charged with here?
Yes, sir.
Was there any loss?
No.
No, sir. Well, that's a good thing. Third-degree felony means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $500. Also, this other case, cause number 22-41050, will be dismissed. Is that your understanding of the big plan? Yes.
Yes.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this third-degree felony? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? So
Yes,
you have to speak up. So
sir.
did you understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered and down.
No objection.
Without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your attorneys. All of this is true, so help you God. State's Exhibit 1 is made a part of the record for all purposes. I'm going to follow this agreement. Pre-sentence report.
Yes, sir. It is.
If nothing further, I'm going to find you are pleading guilty today voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1. Confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 10 years in prison. But I'm going to suspend that, place you on regular probation for 10 years. You must pay a fine of $500. There will be other terms and conditions of probation, which are normal and customary for this type of offense. I do not know what your criminal history is. Do you know? What is it?
I have MCRP in Houston,
So is there some for what?
controlled substance.
Okay. All right. And is it this fraud here that was the reason why the probation was filed to revoke?
Yes, sir.
Okay. Well, okay. You need to fix all that. And
Yes, sir.
are you, what are you doing about your living status?
Stay with my mom.
Okay, you've got a place. It says you were a transient from Beaumont. Is that not true?
Transfer.
Transient, that means you were homeless.
Oh, no, I live with my mom.
Oh,
I
really?
lived with her for.
Good. All right. Because it's not safe to be out there, living off the streets,
Yeah.
and you get in trouble when you do. Or it's certainly dangerous. What do you plan to do?
I plan to go home and go get a job, and
Like what? Doing what?
I wanted to get my TWIC card and stuff like that, but I can't do that now. So I'm not sure yet. I do
You
plan to
haven't-
get a job.
What is your education?
I got my GED.
You do have that,
Yes.
so you have an equivalency. Okay, well, that's, you ought to try to move, or you're a smart person? You make good grades?
I'd say so. Yes.
Good, well, then get into college or a trade and do something with that, and then next thing you know, you got a niche that's making a lot of money and that's needed. There's always a place for everybody who's willing to work. This motion to dismiss on this other case has been signed, so that other case is dismissed, okay? Good luck. Yes, ma'am. Okay. Roger East,
That's also trial and hits and hold on him.
Isidore Reyes,
We need him to go out.
what are we gonna do on that?
He has two motions to revoke and a new case. He's gonna plead true on the motions to revoke and then we'll decide with no agreement
Reyes, Isidore Reyes,
to
please.
determine how we're
Isidore Reyes, that's you?
gonna. Right here, sir.
You were here with your attorney, Mr. Dusler, and the state's attorney. There are three cases that are pending. Two cases, 23 CR 805 and 806 are cases where you were placed on regular probation for burglary of a habitation last year on the same date, July 25th. And there are 6 allegations, including violations, including not only failing to report, but most importantly, a burglary of a building on or about December 6th of 2023. The new indictment, 24 CR 309, alleges that very allegation, that crime of the state jail felony of burglary of a building. And it alleges that on or about December 6th, 2023 in Jefferson County, Texas, you committed the state jail felony of that burglary of a building. Which would be, of course, a violation of your probations. The very first requirement is that you commit no offenses. And that would be an offense that's similar to burglaries of habitation. Where are we?
He's gonna plead true on motions to revoke probation.
What's the plan?
It's unagreed. You make a decision on that and then we will dispose of the new burglary case.
Is that
Depending
what
on how you.
is that what you want to do, sir?
What is that? I just want to run them all together, run them all concurrent. I don't know whatever you can do.
That probably will happen.
Okay.
But you are looking at up to 10 years in prison
Yes.
on these first two that you're on probation for. And then the new case is up to 2 years in the state jail. But generally, I run these concurrently together, but even if that, and I don't know a lot of the information, I can't decide until I hear everything before I really make my final decision. But at the least, you are facing no less than 2, no more than 10 years confinement in prison on these two cases of probation if I decide to revoke your probation and sentence you. So that's serious enough. But is that what you want to do? Proceed this way?
Yeah,
Have you had enough time to think about it?
yeah.
All right. In these two cases, let's start with the motions to revoke probation. Does the defendant waive formal readings of these? Can we proceed in summary?
Yes, sir. Yes.
In summary, sir, these first amended motions to revoke probation in each case, 23 CR 805 and 806, similarly allege that on July 25th, 2023, last year in this court, you were sentenced to 10 years in prison, probated for 10 years for burglary of a habitation in each case. Is that true?
Yes.
Let's go to the first amended 5 in each case. That alleges that on or about December 6th, 2023 in Jefferson County, Texas, you committed the offense of burglary of a building. Do you understand what you're charged with in each of these motions?
Yes.
Is that true or untrue?
Well, I'm truthful.
What he just read.
I don't know nothing about the case.
He just read it to you. You know, I discussed it.
What we're gonna do, Nan, what he just said, I don't know anything about the case. That's kind of the cat out of the bag. We're gonna set this for a hearing. When can y'all be ready? I don't like to hear that.
Whenever.
Yeah, okay. You got 2 weeks.
If I got a chance to get just some help, go to ISF or CP, I'll take that.
I understand, sir. Well, I'll consider all kinds of options, but the first step is we have to decide whether you are guilty or not guilty of misfractions. It has to be one step. And then if it is true, your probations are revoked, you're guilty of this new crime, then I will decide what should be done. And that's the next step. But if you don't know anything about the case, like you're saying, that's not that I'm not going to allow you to move forward today. If you, like you said, I don't know anything about the case. Well, you need to know
I
something
know I
about
got
this.
indicted on it, but I don't know what happened on what, that's about it. I know I got indicted on the case.
You haven't talked to your attorney about the facts of this case?
No. I don't know what I burglarized, or I don't know what they got on me, I don't know, none of that.
It's going to be 3 weeks. You're going to have 3 weeks. Okay, we're going to have to reset in 3 weeks and then we'll hear everything. And then I'll make my decision.
Judge, we, in that.
All right. Are you Janisha Lindbergh?
Yes, sir.
This is 23 CR 1127. Go ahead. Mr. Morian is your attorney here, and you were charged with the first-degree felony of murder. So we can see this is a most serious offense. We can see why the bond is now $500,000.
Yes, sir, that's correct.
Go ahead. What do you want?
Judge, first of all, I think probably while we're on the record, probably need to go ahead and profit the court that, well, I can say for we would waive any type of public safety report. And I would go on the record as her attorney of record and tell you that she has no prior criminal history of any substance as far as anything violent or anything that I think would cause the court any concern in that respect.
Does she have any criminal history? You're,
No, that's fine, Judge. I can.
have you lived in Jefferson County your whole life?
Yes, sir.
No, you're out of Baytown. What? When did you move to Baytown? When did you move to another county?
Next year,
Last year. You've been in Jefferson County your whole life?
yes.
All right. I'm looking at the criminal history over there and it's showing nothing.
I didn't work.
Go ahead.
Judge, when we were here in court last time, we called one family member, which is her stepmother, as well as a minister that it's at her church. And that evidence was brought to court showing that we believe did not have any, had community ties, did not have any, really no flight risk, has no criminal history. Here with her today is her father, Gerald Limbrick. And every time we've had court, she's had a number of her family members here. The co-defendant in this case, Judge, I believe is an older gentleman that I think that will bear out is that he has a long criminal history and that he was kind of a controlling person.
Who is that?
Jamal McCain, Your Honor, is the co-defendant.
And that's the person, Judge, that is alleged to be a trigger man, along with another undisclosed or unidentified co-defendant, potential co-defendant that has not been found yet. When Ms. Limbrick when she found out that there was something going on that the law enforcement was looking for, she turned herself in and cooperated. She has, since she has been incarcerated and being held in Jefferson County, she's only had one infraction that I'm aware of, and that is that she had an argument with one of the jailers, and the jailer and her, I guess, had a disagreement. She told the jailer that she was going to turn her into her supervisor, and so I think that's the only thing that's happened since. The family in this case is willing to try to pull some money together to try to make a bond for her at $500,000. They're unable to do so. But if the bond were lowered to somewhere in the neighborhood of $125,000, they could probably make that work and get her out. But I would tell the court that she's has cooperated thus far and is still willing to cooperate and assist. We were just recently provided with what I believe would be the balance of the discovery by the state, as far as I have been informed. But that is 1 terabyte in an external drive, 1 terabyte of information that we're going to have to go through. And from, I guess, a somewhat selfish standpoint, and being able to try to prepare the case if it does need to go to trial, Judge, would be extremely important for me to be able to have her out, to be able to do that. And I think, Judge, that if the court were to lower that bond and have other bond conditions such as an ankle monitor and curfew and any reporting requirements and anything of the normal conditions that go along with that she would definitely be here when she's supposed to. There'll be no problems. And I would proffer to the court that the evidence, and if I call her father, would be that she does not have any money, is not able to do this on her own, but that the family would be trying to pull together like they had hire up my law firm to assist in her making her bond. But once again, Judge, she has a very large family. She turned herself in. She's cooperated. She's continuing to cooperate. And I feel like she's a kind of person that would not be a flight risk at all, and has no passport, no ties outside of the state as far as family members go or anything like that.
Anything else?
No, Your Honor.
Anything you want to say?
Your Honor,
Okay.
they just believes that the 500,000 is appropriate. Again, the co-defendant, the co-shooter, who hasn't been identified yet, is still on the loose, and the court reviewed the text message last time with and Detective Heather Wilson testified, showing that the defendant here had acted in concert with the co-defendant Jamal McCain to kind of set the victim up in this case, and still believe that she could potentially be a danger with the co-shooter on the loose as well.
All right, you heard what they said.
Yes, Judge. And what he's stated is accurate as far as what the evidence was in our last hearing, Judge. I would just simply point out that without any prior criminal history, the co-defendant, who is the alleged shooter in the case, has got a long criminal history. And I believe that this would bear out that he had manipulated and used this woman for a long period of time. Although that's no excuse, that's not someone that would be out influencing her. And of course, with conditions of not, being in places of disreputable, harmful character, not being around people that have criminal histories of it, she would be able to abide by that.
You're saying, it sounds like your argument is she's naive. She's 30 years of age, right?
Yes, sir. I understand that.
All right. And this happened
Judge,
June of June of 23. So
That's when she was arrested. Yes, sir.
no, this is when it says on or about June 6, 2023 is when this occurred. It's what I'm reading from the indictment. Is that wrong?
That is correct, Judge. June the 26th is, I had June 6th is when she was arrested, Judge, but I think I agree with you. I'm sure that that's correct.
Okay.
But I think it was the day after the occurrence that she got word that they were looking for her. She voluntarily went in and and turned herself in and gave a statement.
The co-defendant is at $1 million, right?
That's correct.
I think that was what compelled the court. Remember what the defendant has been indicted for, of course, is the most serious crime other than capital murder. The homicide, intentional homicide of another. And so it has its high degree of importance from the time of bond, in spite of the presumption of innocence standard. Article 17.15 of the Texas Code of Criminal Procedure is what sets all the rules for fixing the amount of bond. And I went over those. I always do in bond matters to ensure that the T's are crossed, but the court doesn't know what these facts are. I have to rely on the parties, and I have a probable cause affidavit here that gives me some information. And what we're able to glean is, for example, criminal history. It's one of 8 different issues that are to be evaluated by the leading case decisions on this matter. Then you've got 5 criteria under the statute that are to be looked at. And I do look at those and weigh whatever evidence is presented on those. And that's how I make my decision in all cases. And I lowered it to $500,000. I don't see anything different today from what I knew about last time. But it's always open for additional information so that the court can be more informed.
And Judge,
But that's the way it is.
yes, sir. And I can tell you, there is nothing new has happened other than the fact that I've got a terabyte of information that I have to go through. And hopefully we'll get something worked out in this case. She is going to continue to cooperate, and I'll talk to the state about that as well. With whatever conditions the court came up with, whatever the conditions would be that would reassure the court that she would be, I just don't see that there's any danger to the community. I don't see that there's anything that will, and it's a serious matter, Judge. I understand exactly. I'm not trying to.
There certainly seemed to be a danger to this individual who is deceased.
I think that.
That. Did I hear something over there? No. But what the court knows is the same information I had that I reduced the bond in half last time. If y'all can produce something more of a product of advancement in this case, but
The only thing,
because it seemed, even the state seems to say that she's a co-defendant here, and I get the inference she may not be as culpable as the other, but I don't know. I don't know.
I think,
Okay.
yes, sir.
Now we're just arguing the same arguments. When y'all get me some evidence, some information that I don't already know, let me know. And if there's something in the way of what she's doing, I'm always anxious to reward people who want to cooperate and do the right thing. But she's presumed innocent, and she certainly doesn't have to help.
Well, Judge, I don't know if the court at the last hearing knew that she had actually cooperated initially.
I don't know what she's, when y'all say cooperate, that's such a generic term. Everybody's got to be, articulate, particularize
Yes, sir.
information, not just they cooperated. Okay, thank you. Well, I'll reduce it to $10. I mean, what does that mean? Cooperation has no end of, could be somewhat, moderate, makes a big difference in the case. I don't know what it is. But just the fact that we're in cooperation, nobody to this day has told me what that is. And until y'all give me information, I'm flying in the dark.
Judge, I don't know if the information that I've given you would be reliable enough, but what I've told the court was that she came in and she gave a
He
statement.
should, well, they should know what kind of information, and I have a probable cause affidavit, but they should be able to tell you. Anyway, I'm burning daylight.
Thank you, Judge.
And let me know what materially is different, so, because I can bring her up immediately to hear some more information.
Janice, hold on a second. Judge, will we get a reset date from the coordinator?
It's for an announcement.
What, I think, Judge, what
We're gonna set it for a regular announcement, right? Unless you want to just put it on the trial docket now, but you're not ready, you say. We're gonna do this. We're gonna put it for an announcement, but if you have some additional information that you can articulate that's substantial in making a decision, tell us, and then we'll set it immediately.
Yes, sir.
Okay, thank you.